lady. I'll just pick up a couple of points that arise from questions that my Lady Hale asked me before the lunch adjournment. In particular, I've been given, helpfully by counsel for the intervener, some information about the proportion of housing benefit claimants who are also receiving other welfare benefits. And as I understand the figures, 61% of housing benefit claimants were passported to housing benefit from income support or income-related benefits that we're talking about, and that, I think, is from the DWP's quarterly benefits document, and that's the August 2017 one. No one's jumping up and telling me I've got that completely wrong.
So 61% were passported.
61%
Passport, of course, comes as a result of being in receipt of what, for the sake of shorthand, we'll call subsistence benefits.
Yes, and my point was simply that Parliament was plainly aware of passporting and therefore plainly aware when changing housing benefit rules, in particular, most starkly, in relation to introduction of local housing allowance, that would impact on those people whose other income was subsistence benefits. And that has to be taken into account as part of the policy of housing benefit and of the local housing allowance. And in a way, I don't want to take a long time over this, but we submit that you can see the same policy in relation to tax credits and in relation to the changes that were made by the 2002 Tax Credit Act. And you've been referred this morning by my learned friends to parts of a number 10 white paper, The Child and Working Tax Credits from April 2002, which is at tab 43 of Authorities Bundle 2D, starting at MS 1848. And we respectfully submit that just by looking, for example, at section 2 of that document on page 1855, the role of tax credits, paragraph 2.5, for example, talks about tax credits in the last sentence, smoothing out people's incomes over their lifetime. Paragraph 2.10 talks about the income tax system providing a light touch and non-stigmatizing way of measuring income. And paragraph 2.13 talks about building on the definition of income used in the tax system, extending the approach currently taken with middle and high income families to all families, aligning the income test for new tax credits with the income tax system means that income is looked at across the tax year as a whole. So there's an indication there. We submit. We see it again, for example, at paragraph 3.8 on page 1864. In relation to child tax credits, creating a single credit payable to those in and out of work at the same rate. The alignment will benefit many workless families who currently receive less support for their children than low-income working families. For example, this will mean that a family on income support with 2 children under 16 will receive an additional £9 a week compared to the current system. It's a system that is being reformed in relation to what we've been calling subsistence benefits and housing benefits, and treating benefits as providing income as a whole, with the applicant having the decision as to how to spend that income. And as I set out from the local housing allowance white paper, it being an option to stay in more expensive accommodation and supplement that from your other income. In our respectful submission, therefore, it isn't safe simply to say, it isn't correct simply to say, that because in the 1980s the subsistence benefits may have given chunks of money to people for different particular things, and as the intervener has said, even then benefits were not calculated by reference to a basket of items so as to necessarily exclude housing costs, and as we've suggested, income support was available to meet some housing costs, for example, by way of service charges. By the time you get to the mid-90s, when housing benefit is being calculated on averages rather than actual rents, by the time you get to the early part of this century, when local housing allowance is specifically designed as an allowance towards rent that people will know in advance is available, and landlords and tenants alike can make their choices on that basis. In the knowledge that 61% or whatever proportion, but a large proportion of people claiming housing benefit would also be dependent on income-related benefits of other kinds for the rest of their income, with tax credits also adopting this policy of treating income as a whole, there is simply no identifiable basis for the appellant's case that there is this bright line between what he calls subsistence benefits and housing benefit, nor does he have any answer for the question that we asked, which is, if he's right, then what did government intend people on benefits to do about the fact that housing benefit was not going to meet 100% of their housing costs? Did it intend them simply to apply to the local authority as homeless and get cheaper accommodation? And I'll come on to that in terms of addressing the consequences of the argument. Did it intend them to make the sorts of decisions that we have been talking about? And if it is unaffordable, there is a safety net in the homelessness regime where local authorities can make a decision that they couldn't reasonably be expected to continue to occupy the accommodation in exactly the same way as local authorities make that decision in every other aspect of the question of whether it's reasonable to continue to occupy accommodation. In other words, when deciding whether you should have stayed because, for example, it is said there was antisocial behaviour being carried out in the locality which meant that you couldn't safely stay, the local authority carries out inquiries and may ask for information or advice from anyone it sees fit to ask for that advice from, and then makes its decision. And we submit, going back to the scheme of Part 7, there's no indication, leaving aside the guidance which I'll come on to, that the approach to affordability was intended to be a highly technical approach dependent on, in effect, disregarding the other benefits which a person is entitled to. Can I then come on to the question of the authorities my learned friend relied on in relation to subsistence benefits? And
before you move on to
yes.
that, I think that the logic of your argument is that housing benefit can't be expected to cover the rent, that there must be an element in the income support, using that term as a generalised term for various benefits, to top it up. Is that the simple way of putting what you've been arguing?
What we are submitting is that housing benefit, as my lady says, cannot be expected to cover 100% of the rent. It may be that other benefits can be used to top up housing benefit.
Well, I thought the thrust of your submissions about everything, all your income being taken
Yes.
as a whole, must be that we must take it that income support includes something to top it up with?
Talking about income support by itself.
I'm not. I'm talking about it as a global term for all of those various
I'm grateful.
benefits.
I am not saying that there is a specific sum which is included in the calculation of those benefits to cover the shortfall in housing benefit. What I'm saying is that Parliament expects people to make the income they have prioritised for the expenses they have, including housing, and if that is unaffordable in a given case, the local authority will not consider it reasonable for them to remain in the accommodation. But it's not to be premised that it is unaffordable simply because housing benefit doesn't cover everything.
No.
And simply because, I'm sorry.
Can you help me, therefore,
Yes.
on how the amount of income support is set? I don't mean for an individual. I mean, how do the basic rates get fixed? There must be some known formula.
As I understand it, the evidence before this court is that the way that rates get set is by reference to a variety of factors, including the overall welfare budget that's available, the decisions of ministers as to the need to incentivise work, and perhaps I can take you to Ms. Garnham's statement.
I was really wondering about how they decide how much the average household is going to need on gas, electricity, bread, all those sorts
Well, that's what is said, as I understand it, to be common ground, that government doesn't look at individual elements of expenditure when setting these levels.
So interveners, documents.
So at MS page 481, starts the heading calculation of income support. And at paragraph 30, she says that the statute left the detail of what elements were included in an applicable amount to regulations. And then at 31, she sets out elements of entitlement that were added together.
That actually tells us how those figures were arrived at.
Yes, but it doesn't tell us what those figures were intended to cover by way of costs.
But the premise upon which you're working is that they were intended, if necessary, to cover an element of housing. And
Well,
to do that, to know that, you need to know what it is made up from.
Well, my premise, respectfully, is slightly different. My premise is that what we are principally dealing with in this case is the scheme for homelessness, not the scheme for welfare benefits. So the question of whether or not somebody could be expected to make up benefits to cover elements of their housing costs is to be viewed in that context. Now, I am, in this part of my submissions, addressing the argument that there is a bright line between income support type benefits and housing type benefits. And I am respectfully submitting that that conclusion cannot safely be drawn because it is clear from the policies of housing benefit reduction and income support replacement that Parliament was not drawing those distinctions. So that, yes, I do submit that it was in the contemplation of the government when making these statutory provisions that other forms of benefit may be used to top up housing costs, but that was not by reference to allocating any particular sum into those benefits to cover housing costs. The whole point, we respectfully submit, of the changes, including the changes to housing benefit, was to say to people, this is the amount of money you've got overall, and you have to decide what to do with it. Now, where I agree with the submissions made this morning is that if that is unaffordable under the scheme of Part 7, then a local authority faced with a homelessness application cannot treat that person as either intentionally homeless if they've left it or as not homeless if they're still living in it, because they have unaffordable accommodation. But what we submit is that in carrying out that exercise, there is no presumption of the kind submitted this morning that people whose income is derived from out-of-work benefits are not able to, or should not be in any circumstances expected to, or generally expected to, or however it's phrased, pay any amount of those benefits towards their housing costs because of some principle in the benefit scheme itself that precludes that. So our case is not that there are £50 here for food, £30 in child tax credits for clothes and all of that, and here's £25 a week for housing, but that benefits policy is to require, and we see this also in relation to the benefit cap, require people to budget people who are out of work, to budget their incomes in the same way that it said people in work have to budget their incomes. And the City Council, I make it clear, expresses no views about whether that is a good or a bad policy, because that's not my role and it's not its role. But we simply suggest, respectfully submit, that is how it works. And indeed, yes, and I'm referred to paragraph 38 of, what is it, the statement? Of Miss Garnham's statement on page 486. And she says that these amounts amount to an assessment that the applicable amount is the amount necessary to maintain a basic standard of living before taking into account housing costs, which are dealt with separately, which is reflected in the way that these have been described, and refers to a letter that says this is the amount that the law says you need to live on. But that was the passage that you were taken to this morning. But of course, what you need to live on is a term that could include or could exclude housing costs. It's not definitive either way. I was going to just move on quickly to talk respectfully about the points that were made this morning about the meaning of subsistence benefits. I don't need to go to all of the cases that my learned friend went to this morning. In relation to Humphreys, we simply drew attention to the passage at paragraph 22 that the court was taken to this morning. My learned friend refers in his printed case to the case of Hockenjoss, which is at Authority Bundle 2B, tab 22, MS 1205. If I could just go to that briefly, this was the case in which a father who had joint caring arrangements of his child challenged the job seekers allowance scheme on the basis that it was discriminatory because the money was all paid to his ex-partner, even though he had part of the responsibility for looking after the children. And there's reference in the judgment of Lord Justice Ward, paragraph 167, page 1237. To the battle lines drawn between the parties over the justification, in discrimination terms, for linking the responsibility to receipt of child benefit. If I may, I hope not unfairly or completely summarise Mr. Payne's case, he seeks to justify this rule by relying on administrative convenience, cost-effectiveness, and consistency, and the aptness of child benefit criterion for judging responsibility for a child. And he says at 168, there are, however, overwhelming arguments to the contrary. They include the following. Far from the chosen means reflecting the social policy aim, it defeats it. According to Mr. Binns, the scheme was designed to provide a subsistence level of support for those in need, in this case the family and child through the family premium and the child premium. When the child is living with her father under this shared residence order, she is in need at least of the roof over her head, the heating to keep her warm, and the food and drink to keep her nurtured. And without that, he says, without it rather, she would be living below a level approved each year by Parliament. From what resources is the unemployed father to provide this? And he says not from his individual allowance. Now, if I can then pick that up at 201 on page 1245, he says, as I've already indicated, it should not be beyond the wit of man to isolate the amount built into the allowances to cover ordinary costs of board and lodging and keep, the true subsistence figure. So the authorities from the higher courts don't all suggest that housing costs and subsistence costs are insulated from each other. Indeed, in a case for example, in this case involving job seekers allowance, Lord Justice Ward was talking about the true subsistence figure as including board and lodging. Now, I don't say that that means that subsistence has a particular definite meaning in the sense that for all purposes one can say that job seekers allowance should include housing costs. But what I'm saying respectfully is that this suggestion that because a benefit is a subsistence benefit, there is no way in which it can be expected to cover housing costs isn't as clear-cut as perhaps it was presented this morning, and indeed we say it's not correct. Similarly, the SG case, which my learned friend took the court to this morning, this was perhaps one of the starkest examples of the recent changes we submitted was in benefit policy, because it was the policy of capping subsistence benefits not only at a level below the amount which, by simple calculation of the amounts people were entitled to, would have been paid, but using the methodology of taking off people's housing benefit. to start with, so that if anyone, other than for purposes of this, if people are on benefits totaling more than £500 a week, their benefit would be overall reduced to £500 a week, and the way that that would be achieved would by reducing housing benefit, though not below, I think it was a minimum level of 50 pence a week, because if they did that, it would have an impact on other benefits. And my learned friend argues, well, it was not said in that case that people should use other benefits to pay for the shortfall. But nor was it said in that case that those who were affected by the benefit cap would be unintentionally homeless. The passage my learned friend took the court to didn't say that. What it said was, if accommodation becomes unaffordable by the application of the benefit cap, then the person would not be unintentionally homeless. So one would have thought that the easiest argument for the government to have employed in justifying the benefit cap would have been, well, actually, nobody is going to be worse off, because if the benefit cap is applied to somebody, then their housing benefit will be taken away. They're not expected to use their other benefits to make up the difference. They can apply as homeless, be unintentionally homeless, and the local authority will find them somewhere to live at a level of whatever remaining housing benefit they have left. The problem with that argument, which we say is the consequence of my learned friend's argument, is that it deprives the benefit cap of any substance. It takes away people's housing benefit, but it requires local authorities to replace it either with a benefit in kind of accommodation for which they don't charge the full amount, or to move people into accommodation, which, as we know realistically, in most cases is not possible.
But the whole premise of the benefit cap was that it was designed to, firstly, try and encourage people to get into work.
Yes.
But also, if they couldn't afford to live where they did on the benefits that they had because of the benefit cap, to move.
Well, the premise also included, with respect, the argument that the state should restore confidence in the benefit system by demonstrating to the public that there was a maximum amount that it was prepared to pay people on benefits.
Absolutely.
Sharing the burden of austerity, as it were, with people who were in work. Now, when it talked about people moving or people getting work, that was in the context of justifying why the discrimination, or explaining why the discrimination was justified.
Well, most of the comments that we've been taken to have been explaining why certain things are justified.
Indeed.
Not directly on the point that we're on, in fact.
No, and my lady, when I come to Burnett, which I'm going to come to next, I'm going to respectfully make that point. But I'm taking this slightly out of order, but the consequence of treating the welfare system in the way that my learned friends do, and my learned friend Mr. Westgate said it has to be addressed, and I respectfully agree, but he says, well, what we say is lots of people will already be homeless. But the consequence goes further than that. Because what it means is that everybody whose housing costs are not paid entirely by reference to housing benefit, who is also on the passported benefits, which seems to be around 60% of claimants, will not only be homeless at home or unintentionally homeless, but in terms of any accommodation that they have to be found by the local authority, because that has to be suitable, which imports the same affordability test, then they have to be found accommodation for which they are charged no more than the amount of housing benefit that they get. That means either the local authority has to find them accommodation at that level, which, as we know, and as I'm sure my ladies and my lords know from the matters that have come before them, is not something that can readily be done for the numbers of people we're talking about. Or the local authority has to decide not to pass on the costs of the rent to them. In other words, to subsidise their rent at the level to make up the shortfall between housing benefit and the full rent. And that, in my respectful submission, is not merely a consequence that has to be faced, but casts significant doubt on whether that can be said to be central government policy. Seeing as that's what's being addressed in this submission. May I come then to Burnip? My learned friend took the court to paragraph 45. I'm sorry, it's tab 5 of Authorities Bundle 1, MS 701. Again, as my Lady Hale has just put to me, this was another one of the discrimination cases, and as Lord Justice Maurice Kay said in his judgment, paragraph 24 on page 712, it was satisfied that the element of housing benefit there being considered, namely the room allowance under the local housing allowance, which meant Mr. Burnett was only entitled to one bedroom, not two, and therefore had a shortfall, was discriminatory under Article 14. And for the reasons set out in the judgment of Mr. Justice Henderson, the Secretary of State has failed to establish objective and reasonable criteria for the discriminatory effect. In Mr. Justice Henderson's judgment, at paragraph 39, he points out that there was, in any event, a housing benefit shortfall between of £36.81 rather than £59.99, even if this policy had not been adopted by the government, so that the appeal, even if it succeeds, would only ameliorate, not eliminate, the amount of the shortfall. And then at paragraph 44, I accept he's talking about the wider benefit context, but it's in the sense of asking, can that wider benefit context provide objective and reasonable justification for the discrimination which we have found to be established? And his answer was, as you've seen, that it couldn't. But one has to be, in my respectful submission, quite careful about simply applying that reasoning into a completely different statutory scheme. First of all, whether or not the Secretary of State, who has promulgated a discriminatory scheme, can rely on the fact that people have other benefits to justify that discriminatory effect, is a very different question, in my respectful submission, from whether or not a person who has not paid his rent could have afforded to do so. I appreciate that the language of paragraph 45 does talk about separating housing benefit from other benefits, although it's worth bearing in mind that the benefits in question in that case were incapacity benefit and disability living allowance, not these benefits. But
we were told that the amount was the same.
Yes, but disability living allowance, for example, is disregarded altogether for housing benefit, or was disregarded altogether for housing benefit purposes. he also had a student loan in that case. So there was a difference. But the main point we respectfully submit is that the reasoning in saying that the Secretary of State couldn't rely on these other sums to justify discrimination doesn't simply apply across into a completely different, non-discriminatory statutory scheme that is not challenged in these proceedings. What Parliament has done is provided for a system in which people who can't meet any shortfall from their other income, whether it's benefit income or whether it's any other form of income, earned income or anything else, have to be assessed by the local authority if they apply as homeless, in order to see whether or not they could have been expected to have paid that rent on the basis of it having been affordable to them. Just before I move on to the next issue about the guidance, my learned friend, no, actually, can I deal with that when I deal with the guidance? I was going to deal with my learned friend's discrimination point, but perhaps I can come on to that with the guidance itself. My ladies, my lords, you've been taken to paragraph 17.39 and paragraph 17.40 of the guidance. Can I ask you to take up the guidance which is at Authorities Bundle 2A, tab 17. And this is at MS, well, if we can start at MS 956, because there are other parts of the guidance which bear on this question. And at MS page 956, hopefully is the beginning of chapter 8, which at paragraph 8.1 says, this chapter provides guidance on how to determine whether a person is homeless or threatened with homelessness for the purposes of part 7. And as you know, the question of whether someone is homeless includes if they have accommodation but it's not reasonable for them to continue to occupy it, so it imports the same question. And in that context, affordability is dealt with at paragraph 8.29 on page 962, where the Secretary of State says, one factor that must be considered in all cases is affordability. The 1996 order requires the Housing Authority to consider the affordability of the accommodation for the applicant. The order specifies, among other things, that in determining whether it would be or would have been reasonable to continue to occupy, Housing Authority must take into account whether the accommodation is affordable for him or her and must in particular take account of A to D. And that is all that is said there.
Well, they're the same three factors, factors,
yes,
as that are in 1740, aren't
yes,
they? 1740 merely expands upon.
Yeah, well, I'm not saying that 1740 is irrelevant, but perhaps I can come to what I'm saying when I've just gone to one other part of the guidance, which is at MS 96. No, I've just done that. MS 985. 11.1. This chapter provides guidance on determining whether an applicant became homeless or threatened with homelessness intentionally or unintentionally. So this is the guidance on intentional homelessness. And at 990, paragraph 11.22, reasonable to continue to occupy the accommodation. An applicant cannot be treated as intentionally homeless unless it would have been reasonable for him to continue to occupy. Guidance on reasonable to continue to occupy is provided in chapter 8. be necessary to give careful consideration to the circumstances. We make the point, not that paragraphs 1739 and 17.40 are irrelevant, and I'm going to come on to them next, but that in relation to reasonableness to continue to occupy in the context of homelessness under section 175 or intentional homelessness under section 191, the guidance at chapter 8, which is referred to by the guidance at chapter 11, does not make the same suggestions as at paragraph 17.39 and 40, and I'll come on to the significance of that in a moment, if I may. Now, I can take 1739 and 40 either in this document, or if it's more convenient, I'm content to go back to the document that you saw it in this morning, whichever's more convenient. Well, perhaps I'll give you both references. The references in this document is MS page 1030 to 1032. And in volume 1, it's tab 2. Sorry, in Authorities volume 1, it's tab 2, and it's at page 600 and... No, it's not, it's tab 3. And it's at 683. And in line with what the other provisions that we've just asked the court to look at, 1739 refers to, well, perhaps I can start at 17.1 on page 676, or page 1023, depending on which version you have.
When you say version, they're actually the same document.
They're the same document, they're just in two places, and I just didn't want to take you to an inconvenient copy, so I thought I'd give both references.
As long as it's very kind of you, but as long as we know it's the same document.
No, it is exactly the same document. 17.1 makes the point that the chapter is providing guidance on the factors to be taken into account when determining the suitability of temporary accommodation secured under the homelessness legislation. Key factors include the needs, requirements and circumstances of each household, space and arrangement, health and safety, affordability and location. So the context is the suitability of accommodation that the authority is providing under Part 7. And that's reiterated at 17.39, where it refers to section 210.2 as being the basis for the suitability order rather than 1773. And it says that setting out the principal parts of the suitability order, it makes the point that in taking into account income at A, in italics, it's talking about all forms of income, and then in little 1, it specifically refers to tax credits, and in little 2, it specifically refers to such as housing benefit, income support, income-based job seekers allowance, council tax benefit, etc. So we respectfully submit that the Secretary of State was plainly aware of the advent of tax credits in the 2002 Act, when in 2006 he made this guidance, because he refers to it specifically. And we also point out that there are all sorts of other payments that the Secretary of State regards as being relevant to the assessment of income, including two different kinds of benefits, two different kinds of payments made specifically for children. In little 3, court-ordered maintenance payments for the benefit of a child, and little 4, payments under the Child Support Act. Now, I entirely accept the point that this is only being put into the scales. But the question that we respectfully ask rhetorically is, if the Secretary of State did not intend payments that were made for other purposes, particularly the welfare of children, to be taken into account, then they wouldn't be in the order. And the Secretary of State's guidance would be very clearly saying you shouldn't be expecting people routinely to use those sums to pay for their housing. And then we have the payments, the costs rather, referred to at paragraph B, which I don't think I need to go into in any more detail. When we turn then to 17.40,
Mr. Manning, why doesn't paragraph A refer to child benefit?
well, my lady, what I would say is that it's clear that neither paragraph A nor B is an exhaustive list of all the benefits or all the other sources of income that are in play here. Indeed, that's clear from the final words of paragraph A itself, above the subparagraphs, where it says including but not limited to. So it's clear that these are just examples. Maybe the Secretary of State thought these were ones that local authorities would have heard of.
I mean, interesting enough, I was looking at the 1918 order. It does say social security benefits.
Yes.
And they've omitted any elaboration.
Well, in the order, it just says social security benefits even now.
Yes, I know.
Oh, I'm sorry.
In the guide, in the code.
Yes.
And I was going to ask you about the revised code, because it refers, of course, to the universal credit.
Yes.
But it doesn't seem to be quite as specific as the old code.
Well, I think the code seems to have been largely rewritten in 2018. Obviously, to take into account of in 2006, when tax credits were referred to, it was clear government policy to migrate everybody who was on old-style income support onto child tax credits. Yeah. And that never happened. And we see the same difficulties being experienced migrating people onto universal credit.
Well, the problem with the housing department, draftsman keeping up with the changes in the benefits.
Yes. My Lord, yes, but it is something that actually housing officers are well aware of the need to do and have to do for any number of reasons in terms of working out whether people's benefits were correctly calculated and that sort of thing. 17.40, respectfully, in my submission, is the sort of high point of my learned friend's argument that Part 6 reflects his analysis of the welfare scheme more generally. Because it refers to applicable amounts for income support, and that, he says, imports applicable amounts for all three benefits. Because that's effectively what he says was the position in the earlier period, before the Tax Credits Act and before local housing allowance. Now, we respectfully submit four general arguments. First of all, this is guidance which local authorities are expected to follow. And respectfully, it should be construed in accordance with its words and in the light of the statutory scheme on which guidance is being provided. Secondly, as we've seen, respectfully, the order requires everything by way of income to be taken into account and doesn't provide any support for the idea that there should be ring fencing. And thirdly, we entirely accept that the Secretary of State can recommend a bottom line on affordability, and obviously that's what he has done, but the question is where he has set that bottom line. And finally, there's a big difference between setting a bottom line and purporting to, in effect, apply a disregard to the whole of somebody's benefit income without saying so, in terms where, in circumstances where, even above that bottom line, there is no presumption that accommodation is affordable. The guidance is not unaffordable below the applicable amount, affordable above. The guidance is, read as a whole, you have to make your assessment of whether on the individual facts of the case the accommodation was affordable, but below that bottom line, the guidance is that you shouldn't, or that you are recommended not to regard accommodation as affordable. Our references to the earlier paragraphs in the guidance, paragraphs 8.29 and 11.22, are not to suggest that the contents of paragraphs 1739 and 1740 were irrelevant, but to the extent that those subsequent paragraphs are focusing on suitability and the earlier paragraphs are focusing on reasonableness to continue to occupy, it must be relevant, we submit, that the Secretary of State has not referred to this particular paragraph in the earlier context. Not to say that the same factors are not raised, but in the response to the suggestion that there must always be a slavish adherence to every aspect of 17.40, even when you're not assessing suitability, we say it respectfully is misplaced. Even if that's wrong, however, we submit that the guidance should not be construed as my learned friends do. The local authority is criticised for not having followed what it is said that the guidance says, but actually the local authority did follow the clear words of what the guidance provides. What the real challenge, in my respectful submission, is that either that the local authority didn't look behind those words and work out that they ought to have been interpreted to mean something different than what they actually said, or in fact it's a challenge to the guidance itself, except that's not the challenge that's been brought, and it's certainly not something that the local authority is responsible for. And we also respectfully submit, in terms of applying the ordinary words and the clear words of the guidance, that it's not appropriate to try and construe it by reference to historic guidance, because in 2002 and 1999, the statutory context was completely different in terms of other benefits. And in between, there had been a change in relation to other benefits, both in terms of the introduction of local housing allowance, although not nationally, that's clear policy, and was being piloted by 2006 in, I think, 15 local authority areas across the country, and tax credits itself. This guidance in 2006 was plainly issued in knowledge of those changes, given the references to tax credits. And in addition, paragraph 17.40 itself was not repeated in identical terms to the 2002 guidance. I'll come on to that in a moment, but finally, and this also bears on the statistics you've been asked to look at. This guidance is not, as my learned friend said this morning, aimed at benefit applicants. It's aimed in respect of homelessness applicants. The fact that a particular percentage of income support claimants may still have been on old-style income support in 2006 is not the point, respectfully, because, first of all, paragraph 17.40 is simply calculating a figure below which the Secretary of State says you should not find someone affordable, find accommodation affordable. And secondly, even if 60% of income support claimants were still on old-style income support in 2006, that does not mean that 60% of homeless applicants were receiving old-style income support. Professor Bradshaw's figures don't even relate to income support claimants generally. They relate to lone parents on income support.
But does it matter how many it was?
No.
The fact will remain that if you're right about the construction of this passage, there would be some people being treated in one way and other people being treated in another way.
Well, what we say is the Secretary of State's guidance refers to 2006 style income support, not 2002 style income support.
So how was the housing officer to approach that with somebody on old style income support?
Can I come on to that in one moment? Can I just finish this thought and then come on to how it was supposed to be approached? The way that the local authority should be required to act in relation to the guidance is in relation to the overall recommendations provided in that paragraph. The question of what the guidance meant can only, in our respectful submission, be answered by reference to the language of paragraph 17.40 and 17.39 together, rather than simply the one part of one sentence of 17.40. It cannot be said that the Secretary of State overlooked, as my learned friend does in his written case at paragraph 76, the changes to the law in 2002, and meant the same in 2006 as he had meant in 2002, because the language of the guidance is different. Now, this is where we have pointed out in our written case that whereas in 2002, I think it was paragraph 12.7, referred to accommodation not having been regarded as affordable if an applicant would be left with a residual income which would be significantly less than the level of income support or income-based job seekers allowance, which we respectfully submit reflects both that the Secretary of State was envisaging that some amounts of income support or income-based job seekers allowance could be expected to be used for housing costs. And it was up to the local authority to decide whether such amounts would be significant or not. And in 2006, on the basis that income support as it then existed was a lower figure because child tax credits had been taken out, the word significantly was removed so as to apply a baseline, as my learned friend described it, with less flexibility. The only flexibility remaining was the flexibility inherent in the local authority's entitlement to depart from the guidance in circumstances that were discussed this morning for good reason. So it simply does not work, we submit, to argue that the guidance in 2002 meant the same as the guidance in 2006, because the Secretary of State plainly changed it. And did so, demonstrating his knowledge of the existence of tax credits. There's also an additional sentence added at the end of paragraph 1740 about incentivising work, which again, it's not, in substance is not relevant, but it's relevant to the idea that the Secretary of State didn't simply cut and paste paragraph 1740 into the 2006 guidance from the 2002 guidance without thinking about it. I come back, and I'm not ducking it, to the question that my Lady Black asked me, which is what is an authority to do?
Before you go on to it, I'm just wondering where the child tax credit features in the income.
Well, tax credits are referred to in the guidance under subparagraph 1 of paragraph A.
Right. It's the only child benefit that is, like my lady observed.
Well, yes and no. It all depends what tax credits refers to, because tax credits have been in existence for adults for since 1999.
Well, there were working families tax credits. And
there was working families tax credit,
children's.
And before that there was family credit. Working tax credit came in 2003.
Yes.
So, but the child tax credit came in 2003.
The child tax credit in its current form did.
So there were other tax credits in existence before that. That's the only point I'm making.
Yes. I don't think the 2002 guidance referred to tax credits at all. But
there's one way of reading this, which is that both 39 and 40 assume that income support is the whole lot, and that's why they don't mention the children in the income part, and nor do they mention it in 40.
But what we say about that is that the guidance has to be construed in the same way as the order. And the order makes it clear that all forms of income, including social security benefits, are to be taken into account. And that all housing costs and other reasonable living expenses, amongst other things, are also to be taken into account. The guidance makes it clear that it is considering tax credits, and respectfully, we submit you can't cherry pick which tax credits the Secretary of State had in mind. By 2006, the Tax Credits Act was long enacted and in force. The question of whether the Secretary of State should have put tax credits in benefits or in remuneration, or should have been more specific about the type of tax credit, is a challenge that could be taken up with the Secretary of State if there was a challenge to the guidance. In 2006, there were only two tax credits, as I understand it. One was child tax credits and one was working tax credits. Both derived from the 2002 Act. Why child benefit is not referred to as a social security benefit, I can't respectfully answer. And there are a number of other benefits that aren't referred to as well. And one can say that possibly the Secretary of State could have expressed himself in clearer language. But what we say is not a permissible approach to the guidance is to say, well, we'll ignore his references to income support and on the basis that he may have overlooked these changes in 2003, 2002, and meant to say the same thing and have the same effect as he had said previously in his earlier guidance, when we know that this version of the guidance introduced reference to tax credits. So we say, therefore, demonstrating the Secretary of State knew about them. And we also know that he changed the language of the baseline to take out references to income being significantly below the applicable amounts, which demonstrates that this paragraph was not simply reproduced unthinkingly from the earlier guidance, along with the fact that there was an additional sentence added at the end. So if this is an exercise in construction, there is simply no warrant, we say, for a construction that adopts the earlier guidance as having the same meaning as this guidance. And in relation to the particular case, Ms. Samuels was not a person who was an old-style income support claimant. So the answer I would give to my Lady Black's question about what the authority is supposed to do in applying this guidance, in applying paragraph 17.40, is to assess its conclusions, or reach its conclusions on an assessment of whether or not, taking account of the relevant facts in the order, it considers the accommodation affordable, and then to also have a look at whether, as at 2006, the applicable amount in respect of the particular applicant's income support or job seeker's allowance would be above or below the residual income left to that person after having paid housing costs. It is exactly as the guidance suggests, on a real-time basis. If the local authority does that, it has not departed from the guidance. We respectfully submit you can't expect a public body which is statutorily obliged to have regard to guidance to investigate and go on a detective mission to try and work out what it means when it has a clear meaning on its face. That would be to allow for exactly the sort of idiosyncratic decision-making that my learned friend Mr. Westgate complains about. Because every local authority could say, well, we followed the guidance, we thought this particular paragraph meant that. Because in 1999, the Secretary of State had said this, and then we thought, well, if you took that together with this and something else, then it meant X. And that is a recipe, in my respectful submission, not for complying with the statutory requirement to have regard to guidance, but to open everything up to a free-for-all. The consistency is achieved by our construction just as much as it is by my learned friend's construction, because we both agree that the first sentence of paragraph 17.40 is setting a baseline. We just don't agree what the baseline is. If we are right about what income support means in paragraph 17.40, then the applicant's income was, on any analysis, significantly higher than that, so that the need to explain what the local authority thought about that aspect of the case in circumstances where nobody was impressing upon the local authority any questions about what her applicable amount should be taken to be, was, as was found in the court below, not there, not established. If the solicitors representing Miss Samuels, who made a number of representations in relation to the decision of the reviewing officer to serve a minded to letter setting out what he intended to find, which was what led to the revised expenditure figures, and the other submissions that were made about income and expenditure and overall affordability. But nobody suggested at that stage, or indeed at any stage until late on in the Court of Appeal, that they needed to apply their minds to this question of the applicable amount in all cases. And we respectfully submit that taking the meaning of income support in 17.40, together with the guidance provided in 11.22 and 8.29, suggests strongly, and we say conclusively, that the local authority were not in error in failing to set out its position on the point, because it's quite clear what they would have said. Your applicable amount was X and your income is Y, and it's much, much, much higher than that. The real question in the case was whether or not the local authority was entitled to come to the conclusion that the rent was affordable by reference to a weekly income of £311 and a weekly shortfall of £34. And that was the question that they addressed and gave a very clear explanation of. I don't have time to take the court to it. I'm not sure it would help, but the minded to letter is in the bundle, and it does actually take a more detailed approach and say, well, you've told us that the £150 a week that was given in the income and expenditure forms as the expenses on food and household items was probably a weekly figure. But if you make it broadly a monthly figure of £600, you'd still have had the money to pay the shortfall. That was then responded to by a letter saying, well, actually, here are a whole load of new figures. And the food and household items amount had gone up to £750, with a separate amount for clothes, travel, utilities, etc. And it was on that basis that the decision maker said, well, you've told us and we're satisfied that you had the ability to manage your financial affairs and pay your bills on time. The £750 seems an excessive amount, even for a family of your size. And I believe that as a matter of budgeting, there was sufficient flexibility in your budget to pay the shortfall. And we suspect that there was absolutely no need for him to go further than that. That is supported by Barua, and I'm just going to give the court the references at this point, if I may, because I'm living on borrowed time.
You are?
That was covered in your submissions, isn't it?
It is, yes.
I think you're technically out of time, Mr. Manning. But
Well, I'm probably technically repeating myself as well at this point. May I just have a moment just to check?
yes, just check.
There's one other matter I should just explain, if I may, just in 2 seconds, 2 minutes perhaps, 1 minute. We've handed up at lunchtime a table of income support personal allowances backed by the 2005 CPAG publication, just to show where we got them from. The only point we make is that one of the points made against us on paragraph 1740 is that the reference to applicable amounts makes no sense after the changes in the Tax Credits Act, because it would just be the same for everybody. And all we've tried to show is that family composition and circumstances are still relevant, even just in the personal allowances. There were other premiums, we're not disputing that, but even in just the personal allowances, there were 14 different rates of applicable amount. And in the CPAG document behind, it explains what factors were taken into account. It wasn't just age, it was age, responsibility for children, whether parents could have any ability to help out, whether special sorts, but importantly, whether special kinds of accommodation were required. That's on page 880 of the document behind it. So that's why we've handed it up, because we say that the fact that reference is made to applicable amounts is not meaningless simply if it relates to 2006 style housing benefit, because there were, as you can see, so many different applicable amounts, even for just the standard rate, personal allowances.
Thank you very much indeed. I've got 2 copies of this document, so if anybody's
You are doubly,
short of one,
doubly lucky.
they're welcome to have it back. One will do.
My lady, I haven't responded to my learned friend Mr. Westgate's point on discrimination, but in a sentence, all we say about that is the scheme is not discriminatory because the guidance requires individual assessments to be made of every person, every household's affordability. And there is no bright line above and below the applicable amount. If a family of 4 was told by a local authority, you can survive on the adult personal allowance, that would be plainly challengeable on affordability grounds. I don't think I can really justify saying more than that. My lady, unless there's anything further that I can assist with, those are our submissions.
Thank you very much indeed, Mr. Manning.
My lady, if I can take you first back to my learned friend's point when he says, why is this not what we've suggested about the meaning and what IS and CTC and child benefit are intended for, why are they not taken out of the 96 order? Well, the obvious reason is because they reflect the reasonable living expenses, and you then have to take the reasonable living expenses out of the 1996 order, which clearly wouldn't make sense. As Parliament has set those benefits to meet those reasonable living expenses, they have to appear on both sides of the ledger, though our point is that they cancel each other out in the sense that that is the minimum level of what Parliament has intended reasonable living expenses to be. If you were to take them out, you'd end up with the most horribly convoluted and complicated order, where saying this benefit could be taken into account, but that benefit can't be taken into account. And that's not the point. The point is simply that you take everything into account, but you also take completely into account that those benefits are for bringing up children and for your basic living costs. My learned friend was not able to take us to one case at all where there's been any suggestion, as my Lady Black said, of where is there anything in these allowances to meet housing costs in addition. There aren't. They're not intended to meet housing costs. My learned friend took us and mentioned that in service charges might be included in your income support. If I can take you to MS 870, and that's in volume 2A, tab 13. We start with 870, which lists applicable amounts under the income support general regulations. And you'll see applicable amounts in other cases are claimant's weekly applicable amounts.
Sorry, we are at...
So it's 870.
Tab 13.
That's tab 13, it's the very first page.
Yes, thank you.
An amount in respect to himself, you'll see that where little 2 was, that's where the dependent child allowances would have been. The amount of any premiums payable to him, And then E, any amounts determined in accordance with Schedule 3 housing costs, which may be applicable to him in respect of housing costs. It shall be the aggregate of those sums. So rather than those housing costs referred to being expected to be taken out of your other elements of applicable amount, you are given an additional sum in your income support. So if you turn to 874, and there's a list of additional sums which you may be given housing costs for. And that's because housing benefit does not cover any of those sums. That's why you get additional income support for them. So, although my learned friend is right to say that you can get income support for those housing costs, it's an additional sum. You're not expected to take it out of your basic living costs. And there the two systems interlock. You have income support for these residual housing costs, and you have housing benefit to cover the rest of your housing costs. And that simply underlines what Mr. Justice Henderson found and when he set matters out in Burnett, that those costs are not notionally available. And it's wrong, we say, to try and say and hide that under the basis that Burnett was an Article 14 case, because not only by referring to the wider benefit context, when he refers to subsistence benefits, for Mr. Burnett as a disabled person, there were, as I pointed out, because he had incapacity benefit rather than income support, additional sums to reflect that disability because of the nature of his condition. But part of his incapacity benefit clearly was for his general everyday subsistence, his gas and electricity, bread, etc., that my Lady Black referred to. And if Mr. Justice Henderson was only referring to disability-related sums, he would have said, oh, but clearly these other elements are available. But he didn't. And that's because that equally fits in the fact that there are two entirely different schemes of benefit, except where there's one overlap for those extra housing costs, which is income support is for your living costs, your reasonable living expenses, and housing benefit is to cover your housing costs. And I noted a reference by my learned friend in relation to the child tax credit, and how that in relation to child tax credit, we saw, and he quoted, I think, from 3.8 at MS 1864, that child tax credit was also being paid to people in work. There's also reference there to child tax credit being paid at a higher level than old income support. But that simply recognises that the old level was not sufficient to meet those living costs, because both people out of work and people in work received that higher tax credit level. My learned friend sought to say, well, because of what was said in one white paper about housing benefit, and that some people in those circumstances might wish to live in an accommodation that was rather more pricey, they could choose to do so, because there was that flexibility in that old local housing allowance system. Now, equally so, that there may be some people who wish to live in unaffordable accommodation and to live in those circumstances where they spend more money on their housing than on their children or on themselves. But that doesn't, as a general rule, make that accommodation affordable. That's an exercise of personal choice by that particular individual. But so far as the general rule was concerned in relation to that white paper, it must have identified that there is a considerable number of people in housing benefit who aren't on the minimum subsistence level. So they're much more likely to be the ones who might want to spend a bit more money on that sort of cost without it affecting their housing benefit. But what that white paper and what none of the housing benefit changes, all housing benefit legislation says, even if they anticipate that some people might be living with a shortfall, that does not mean that if they leave, that the accommodation was reasonable for them to continue to occupy. The whole point, as we say, is that money was not there was no other money available for them to meet their housing costs. My learned friend's not been able to identify where any other money could be found in income support. And the consequence must be the consequence pointed out by the Children's Commissioner, referred to in SG, that there is going to be an impact on child poverty if you are required to divert sums for the upbringing of your children to meet those housing costs. In reality, what my learned friend in my submission has to say, he has to say Burnip is wrong. And Burnip clearly is not wrong in our submission, that it gives the entirely accurate construction as to the difference of the two schemes, one for income support for living costs and one for housing costs. In relation to the benefit cap cases, you'll recall from the benefit cap case that the government also came up with other reasons, not simply that you could move, but also there was the mention of discretionary housing payments could be provided. But as my Lord Conworth noted in the government's response, they did not respond at all to the point made by the Children's Commissioner that if you divert housing costs, so if you divert children's tax credit or child benefit or to pay your housing costs, then you will be putting risk of putting the child into child poverty. And indeed, in relation to this case, of course, over 80% of the appellant's income came from the child benefit and the child tax credit. Therefore, there would be bound to be a significant effect on what was available to spend on them if she diverted those sums to pay housing costs, let alone the fact, of course, that there was £100 less that she was receiving. My learned friend says then, in relation to the guidance, that one should give the construction, as I understood it, that the 1740 guidance was ossified, so to speak, at the levels of benefit that were available for income support at that time. But that would also give to the windfall, a significant windfall to the legacy claimant, because a legacy claimant presenting today would have the benefit of being told in those circumstances, well, your applicable amount, being a legacy claimant, is far higher than someone who is not a legacy claimant.
Well, it's not a windfall on your submission, it's what they need.
Well, indeed, but in relation to if it would mean that they would be being treated completely differently to everyone else simply because of the time when they made their income support, when they were awarded income support, and the fact they continued to be on income support. As far as the construction of the Code of Guidance is concerned, it's quite clear, this clearly is intended to apply to reasonable to continue to occupy and suitability. Otherwise, all that would be being done would be they would be repeating the same guidance in two different parts of the code. The construction that my learned friend gives to it, therefore, it seems would be this, that there would be the most enormous and striking policy change in 2006, whereby instead of it being the residual income, after you take your residual income being assessed after meeting the cost of accommodation, that it should not be left with you should not be left with a residual income that is less than the level of income support or income-based job seekers allowance that are applicable in respect to the applicant, and of course taking into account the composition of the household, would suddenly mean there was an enormous drop, simply by reference to the fact that there was not an express mention of child tax credits in that paragraph. That would be a bizarre policy change for another reason. It would mean that there would be a situation where the protection given by the guidance collapses and falls away, because it would be a residual income that was so low that you could not expect anyone but a single applicant or a couple, if a couple still applied, to live upon it. It is a construction of guidance that cannot, in our submission, be right, and would mean that the reference to the circumstance and composition of the applicant's household was utterly meaningless, because you would be ignoring the members of the household who do not receive or there's no allowance for in respect of income support anymore. In relation to the change from the 2002 and the 1999 guidance and the removal of the word significantly, there is, we say, a much more obvious inference to be drawn from what the Secretary of State meant. And that was that too many local authorities were in fact treating as reasonable to continue to occupy accommodation where people were significantly below the level of their subsistence benefits. And he took significantly out to protect people in receipt of subsistence benefits from finding themselves with local authorities taking views that one local authority may say £8 was significant, one would say, well, £20 isn't significant. That was the reason why the Code of Guidance changed. It was not as a sort of slight improvement, having taken away several £100 from the level of residual income that the Secretary of State was referring to. What we say in relation to this is these systems are all meant to fit together. The income support system provides you with a basic level of income for an individual. Child tax credit and child benefit provide proper levels of support for children, such that when you put those three subsistence benefits together, you have enough for a family to live on. And that is reflected then, we say, as being the proper assessment of what are a family's reasonable living expenses. That fits in then to the explanation in the Code of Guidance. That's why the Secretary of State, it's a reason why the Secretary of State clearly has gone on to say, that's why we do not think you should be left with a residual income below the applicable amount, because the applicable amount is what is reasonable for you to live on. And what do you do with what's reasonable to live on? You spend it on your reasonable living expenses. That's why I'm in essence returning to my very first point this morning, which is that they cancel each other out to a degree. You don't leave them out, but clearly the reasonable living expenses reflects those three levels of benefit. And equally so, the construction that my learned friend gives to 1740 would really render the first part of 1740 utterly worthless. In all but cases of people who are of single persons applying or couples applying. Otherwise, it would be meaningless. And in particularly, it would entirely fail to protect, safeguard or promote the welfare of children, which until 2006 was one of the things that it plainly did by referring to the need to take into account the composition of the household. That means everyone. If you take away someone's residual income, and so you leave someone with a residual income below the applicable amount, it means that money is not available to spend on the household's living expenses. If my learned friend is right, then the children are in essence being ignored in the residual income figure that is left. It's not rational as a construction. It's not consistent with the purpose of the legislation. And it's not consistent with the situation as which one goes back to the 1996 order. The overriding point in the 1996 order is the accommodation affordable? How do you assess its affordability? You assess it by taking all those matters into account. And if you only take into account a very low level of residual income, that's in essence asking you not to take those matters into account. It becomes a meaningless exercise. And finally, on that point, my learned friends referred to the reasons given by the reviewer, but of course the reviewer in this case does not refer to 1740 at all, in the sense he doesn't refer to the substance of the first part of 1740.
And when was the 740 first mentioned by your side?
In 1740's first mention in the grounds of appeal, at the start of the case, when we say they simply have had no regard to 1740.
What in your grounds of appeal to the county court?
Grounds of appeal to the county court.
Yes, but it wasn't mentioned as a factor to the officer. No,
it wasn't, but there are 2 points I'd make very briefly in relation to that, is that solicitors assisting people in reviews are paid on a very small amount on legal help. But secondly, of course, it's not the role of the appellant to tell the local authority how to do their job. The guidance is directed by the Secretary of State to the local authority, and it's for the local authority to make sure it complies with the guidance. The fact that it may have been overlooked how the guidance should have been applied, or it wasn't drawn expressly to their attention, does not mean that they shouldn't apply it.
Well, difficult though their job is, the job of the local authority officers who are charged with making these decisions has to be the same whether people happen to have the benefit of a small amount of legal assistance or the benefit of a large amount of legal assistance, or might be such as your client without any assistance at all. They have to know how to do the job. For people who don't know everything about homelessness.
Yes, and indeed, and that's why reasons need equally to address all the relevant...
Yes, I mean, I wasn't making up, I just wanted to know as a matter of fact, and I think it's page MS231, is it?
Yes.
In the grounds of appeal.
Yes.
Thank you.
And unless I can assist you further, I have nothing to add.
Just checking that nobody's got anything else to ask of you, but it would appear not. Thank you very much indeed. And thank you to everybody.
So, my lady, there's one thing that my learned friend Mr. Rosden reminds me of, which is that we're going to try and get that agreed note
Yes.
complete.
Yes, that would be very helpful, just so that we've got all the figures set out clearly, so that there aren't any discrepancies, and hopefully they can be agreed between you all, and it'll make our lives a great deal easier. Otherwise, of course, they're not easy at all, because by definition this is a point of law of general public importance, and we have to go away and work out what the answer to it is, which we shall do and let you know in the usual way. The court will now adjourn.